candles on each end here.
Okay, right? Yeah, all right. It's October 25th, 2013, collective bargaining session, Pasco County and Teamsters. Local 79, I'm Jim Sherman.
Vote this month.
John Schultes, representing the union. Bank Building Utilities.
Bruce Lee, facilities.
Warren Johnson, Utilities.
Ed Seitzig, Utilities.
Jim Boucher, public transportation.
Tax Utilities. Tom Longley, Tom Russell, Road and Bridge.
Okay. Here's a hand. Oh, let me keep one. Just wanted to cover an issue that I'm not sure whether you've overlooked or that you misinterpret our position on it, but as you know, with respect to discipline, our position is to exclude discipline from the collective bargaining unit, as is our right under Florida law, which defaults review of discipline to the county's personnel board, but does so under Section B2 standards of contract of the career service rules and regs. So if you look at the top of the second page, you have a two-sided. The standard of conduct under the county's disciplinary standard does include suspension, demotion, discharge, or take other disciplinary action against employees for just cause. So just cause is embedded in the current status quo procedure for reviewing disciplinary matters. I'm not sure whether you realize that or aware of it, or just rejected as because of the vehicle that's used to review it.
Well, first and foremost, it's been your position to not have a disciplinary procedure in the contract pretty much from the onset. And my recollection is we started leaning toward including it, and then we spent some time negotiating some parameters to that. And then once you realized that once we agreed to having arbitration and the grievance procedure, you no longer wanted to have this disciplinary procedure in the contract, from what I understand, because you didn't want us to have the ability to arbitrate a deadlock grievance, excuse me, that is protesting what we perceive to be an unjust termination. And in regards to the question, that if I was aware of this, it's a joke. I've been saying since day one that the county's been recognizing just cause in their policies and procedures. I don't know if you got some sort of amnesia or not, but I've been saying it since day one, Jim. The standard of just cause has always been in this contract, and you've responded knee-jerk every single time. Well, that's a standard that we don't feel we need to have for discipline, or that the county may have a different version of what just cause means. So I'm well aware that this standard's in there.
Well, that mischaracterizes the progression of our position on it. Our position in this is that discipline should not be in the collective bargaining agreement. That's our position today, because it's dealt with elsewhere. It's true that we have explored with you from time to time procedures for bringing discipline into the collective bargaining agreement. But if we're in the collective bargaining agreement, we would not be agreeing to a just cause standard. So I just want you to understand that simply by default, the just cause standard stays in effect. We're not rejecting it as part of the status quo.
No kidding.
Okay.
So the whole thing is what happens when you disagree, or the county, not you, the county disagrees with the local union's interpretation of whether the just cause standard was applied in a case of discipline. What happens then when there's a disagreement?
The disciplinary, the personnel board considers that matter and resolves it. That argument can be made to them.
and they have the final say-so.
No, of course not.
No, that's why there ain't no way.
No, their process is they have an advisory role with respect.
And your county administrator has the final say-so. So if she don't like me, she says, no, the board could say, put him back to work. She don't like me, say, no, fire him. And that's the end of the thing.
She has final say.
And there is no way I'd go for that for anybody in this county. That's what brought this union in here.
What is your proposal today? I mean, is it just to show us that there's, what the reason we're here today, to show me something we've already known about for 3 years?
Well, you've repeatedly said that, or implied that you don't think that we recognize just cause.
I never said
We
that.
do,
I
Judge.
said that you
No,
already
I
recognize
said
it, and that you don't want to put it in the contract for something you already recognize. That's what I said.
That's right, because we would have a different standard if it were negotiated through the contract.
Right. We'd have the standard that an arbitrator would view, and weigh whether or not just cause existed in the case of termination.
That's what the personnel board would do.
Right, and
For no
I mean, it's just like a broken record. I'm just wondering if we just wasted all of this time, all this money coming here today, unless there's something else you need to, that you want to share with us.
No, I wanted to cover that point.
What's been covered was covered 3 years ago.
Well,
You
we're
want to
covering
cover
it
the
again.
point. You want to cover a point that there's a just cause reference in your career service rules and regulations, when I've said pretty much almost every single bargaining session that there was. You telling me something today? I mean,
I'm trying to persuade you to drop your impasse of that issue, to acquiesce to our position that it be excluded from the collective bargaining agreement and enjoy the standard of just cause through the personnel rules.
We already believe the standard of just cause is here at Pasco County with respect to discipline. We just understand that when we disagree with the county's position on whether just cause existed, that we do not have any recourse other than to go to the county administrator and say, hey, we believe the person should not have been terminated. We understand that they've done something wrong in a hypothetical, but their conduct did not rise to the level worthy of a termination. Perhaps an extended disciplinary suspension would be more appropriate. But we can't have that, we can have that discussion, but we can't say, at the end of the day, when the county administrator says, well, I guess we agree to disagree, what do we do then? So we want to have the recourse to go to binding arbitration in the event that there is a disagreement on how the results of a disciplinary matter, if we feel that just cause did not exist. So I mean, I just, our position, you've known our position all along. The union has explained repeatedly that we're willing to work with the county with respect to using the personnel board as a way for flushing out lesser disciplinary matters, or even going all the way to the point of using the personnel board for terminations, as long as we have the ability to grieve at the end of the end result. We can appeal it through arbitration. I've heard Barbara say that she doesn't want to hear the case twice, that she doesn't want to go through everything all 2 times. And I've repeatedly said that, hopefully during the course of everything going through the personnel board and having a hearing and the local union representative presenting its case before the personnel board, that, that in our mind justice would come out. But in those extreme cases where the personnel board, for whatever reason, just completely, absolutely disagrees with the union's position, even though we have compelling evidence and we have everything in front of them, and they still, for whatever reason, just decide to turn the case down, or even if the personnel board agrees with the union, but the county administrator wants to overrule the personnel board. In those particular cases, we have to have an avenue of recourse to assure our members that they're going to get a fair shake when it comes to a disciplinary matter. So we're here today to work out something in that regard. We're all for it, but anything short of it, then our position is unmoved.
All right, well, I was hoping to persuade you to acquiesce to our position to get a contract submitted for ratification.
We want a contract to submit for ratification, and the very basic concept of having a just cause for discipline, provision in the contract is just something that's in almost every single contract, labor agreement, and even the ones that it's not some arbitrators would rule that the concept of just cause exists anyway. You have it in your career service rules and regulations. It's just, I've told people within our union's leadership about the argument, well, what's the problem with Pasco? Would you believe it? They can't even agree to a just cause provision. Once they're done laughing, I say, I wish I could laugh too, but unfortunately, every other employer that we deal with, this is one of the first things that just comes and gets off the table. It's just understood. Every single other employer that we deal with has a just cause provision at Local 79 and the CBA. It's something that the employer accepts. Why is Pasco County so different? I have no idea. But I don't know who the driving force is. I don't know if it's you or if it's Michelle Baker or whomever it is. But apparently, whoever the driving force is taking one or two positions. Either they're naive on how labor relations works, or they think they're trying to do something that has never been done before. At least with Local 79 to negotiate a contract without just cause.
Well, yeah, at least with Local 79, but it has been done before. Not every contract has a just cause provision.
I understand that, but the only thing I can just fathom is that the county administrator wants to have the last word over whether someone is terminated or not. I mean, that's basically what the authority and the power that you want to retain.
That's correct.
Okay, and that's just something that we cannot have. And if that was the case, if every single discharge matter that came before the county administrator, and even though the personnel board who recognizes the concept of just cause, if they even understand what the concept is getting a bunch of local businessmen to sit on the personnel board who have no training or understanding or legal, wherewithal of what just cause even means, to rely on them is scary enough. But then to rely on them and then have the understanding that even if they agree with us, even if I can convince them that the county administrator can overrule it, effectively, the county administrator could terminate every single person in this county, every single person in the bargaining unit, every single person who's a union member. And that's what we're not comfortable with living with. And it's just, I find myself getting frustrated arguing the same point over and over and over and over again. Explain to me this, why is it during our last impasse hearing before the special magistrate that Barbara DeSimone agreed with the special magistrate to having a just cause provision in there?
Like we just said, we were willing to agree to just cause. It's the arbitrator that's the issue. We've said that all along.
Everything in the
It's
contract
the
is
cost of the arbitrator.
everything in the contract is subject to the grievance procedure. Everything that's in there. If there's something in the contract, a provision in the contract that is not fulfilled, then the union takes a position that the contract was violated and it goes before an arbitrator. So by having a just cause provision in the agreement, that allows us to go through the grievance procedure. At the end of the grievance procedure, there's an arbitration provision. So all we're asking is to have a simple one sentence in there. I mean, we're just beating around the bush. You know what the union wants, and apparently there's
We do know what you want. We hope that we would be able to persuade you to remove this hurdle and get a contract that's submitted for ratification. But if you want to go through the impasse process first to get to that point, so be it.
Well, a couple of meetings back, didn't we make the motion that we would leave it up to the employee to go to the arbitrator or go to the parole board,
Yeah.
the personnel board? So now you're only hearing the case once. You don't have to worry about hearing it twice.
But you don't understand, every time you go to an arbitrator, it's thousands of dollars.
How much does Pasco impasse?
It's not,
And
No one near that.
the firefighters have it, they have just cause in their contract. They work for the
And the
county.
ability to
I don't
go
think
to
the
an
cost of
arbitration.
an impasse hearing is much different than the cost of an arbitration. I mean, certainly not for the union side. You're paying about the same amount of money for the individual to come to the hearing and deliberate over it. I mean, it depends.
but you can have more than one arbitration in a year. You can have several.
Okay, but the question was asked, or was it compared to an impasse hearing? And I thought the answer was it's not as expensive, and I think they're about comparable. I don't plan on going to arbitration over discharge matters. I've explained repeatedly the union's position that we are not interested in moving forward with any frivolous cases, and our reputation and record speaks for itself. We shoot straight, we're fair, we are not an in-house union, and I don't understand why if this is such a strong issue with the union, why you can't possibly give it a test drive. I know you're going to say the same thing, but the problem is like I can't get a contract ratified until I have this provision in it. And so if this provision is in there, and you find out in a year that we've taken 2, 3, 4, or even one case that was a junk case to arbitration. Junk meaning the guy was clear as a bell, guilty as sin, did everything wrong, and the union's still moving the case to arbitration. And we're back to bargaining a year from now, and we say, see, union, we told you. We told you that we simply cannot have you bringing every junk case in the world to an arbitrator. It's costing us money. It's wasting our time. Then, you know, if there was something in our record that would lead you to believe that we would do such a thing, I'd probably hold more weight to it. But it's just a simple thing. It's like an on-off switch, you know. No contract without just cause, contract with just cause. And it's a year contract. How many disciplinary matters or arbitrations do you think we're going to rack up in 1 year? Specifically for discipline, because the rest of the contract.
Because you don't fire that many people.
John, we don't have to belabor it. You know, you've done a very good job of articulating the union's position on this issue. There's no question about it. I felt like we did a good job of articulating our position on it, and the fact of the matter remains is that we've been unable to persuade you to our point of view and you to your point of view. So, you know, we had hoped that today that we would be able to persuade you to give it a shot for a year and see how it works. If anything came up, you'd be able to test the personnel board process, and maybe you'd acquiesce to it going forward after that. But apparently that's not the case. You're going to hold your position. We're holding ours. We'll resolve the impasse process against, but we did want to give it one last shot.
We're the ones that are out there in the field and listen to the guys. That is never going to go, you can put it out to a vote, it's going to get voted down. We're the ones that are out there that listen to the 1,200 members. This is what the 1,200 members want, and they're not going to settle for anything else but. So it's going to, even if we put it out to a vote, it's going to get voted down.
Let's test it.
I know, I'm telling you, I listened to, how many people from Pasco County have you spoken to? How many employees?
Let's test it.
It's not going to fly.
I just want to answer, is that going to make a difference? Is it going to make a difference in the county's position? If we come back with a, see, we told you so, and you watch us count the ballots like you did last time, is it really going to make any difference in your position?
No, but I don't think I don't agree that it's a slam dunk that the employees will reject it in the
So if it was a
contract.
slam dunk, you just said it's not going to make any difference in your position. So it's an exercise of futility. It's a waste of money and a waste of
No,
time.
the end result is if we're right and the employees ratify the collective bargaining agreement, it's an issue that's behind us going forward.
Jim, say we reach you for a year, and all of a sudden, 2 guys do something that gonna get them fired. And they go to the personnel board, they go through all that. Michelle Baker says, well, sorry, buddy, if that happens to 2 people during this 1-year contract, who's gonna feed their families? Because you didn't give us a chance to go to the, that's not gonna happen. If it happened, but say it happened. How about if it happened, Barbara? Tomorrow, somebody got in trouble. We signed an agreement today. Now, he has no right to go to an arbitrator. You work for Barbara, and you work for Michelle. And you guys pick people, the commissioners pick people, put them on the board.
I don't pick them.
No, the commissioners do. I know it works. But then, if they all know everybody, you put our livelihood in a chain committee that has one person on top who goes, sorry, you have no, but say if that happens to one person, that's
But
one
you're
person.
assuming that they're being fired for no reason.
But that's if you agree and they agree and she agrees. But how about if the arbitrator says, that wasn't right? Because they don't understand, like John said, they don't understand where, it is.
I think it's going to be a rare case. I think it's going to be a rare case.
Yes.
And to be quite honest, I'm not opposed, and I'm kind of not minding the idea of having to present the case before a personnel board. I really not. I think it's a good idea, but it's just that when we bring the case before the personnel board, and the personnel board votes it down, you know, that the person gets terminated, and how many people are on this thing? 5 people? Okay, because each commissioner appoints one, so it's a 4-2 or 5, you know, it's a split vote where just one more person would have made a difference in whether the person was going to get their job back or not. And in my heart of hearts, I know, just because of having gone through the process enough times, that the case should not have been voted down, and we move forward to arbitration. At least I'll know that, you know, we gave it a fair shot, we went about it the county way, or take another extreme case, we go before the personnel board, and the personnel board just 100% says, no, that the just cause did exist, and that this employee should be terminated, and they uphold the decision. And I go to the member and say, listen, man, you know, I think the case was very strong to begin with. It didn't cost us anything to go before the personnel board, and they voted it down, and I know that an arbitrator would give us the same decision just based on my experiences. And so I can have that discussion with an employee.
Look, in the time that the union has been formed and representing the interest of the employees, how many times has an employee in the bargaining unit been terminated under the standard of conduct provision of the career service rules?
I don't know the number, but I just got a call within the last few days from someone.
And how many times has the union advanced a review through the personnel board in the time that you've been representing the bargaining unit?
0.
So why not?
I don't have.
So why not go another year under that process?
Let me explain something. I got a phone call from somebody, okay, who says that they were pulled into the office because they went to repair a residential water meter, and the woman that owned the property came out, started talking to the county employee, and they were having a conversation, and according to the employee, the woman said, you know, we can talk about this later, and the guy said, fine, when I come back from work, you know, after work, we can, you know, discuss, but they were just, we're hitting it off in his mind. He comes back to the woman's house, and the woman wasn't interested in talking to him for whatever reason. So he goes along his merry way. The next day, or soon after, the employee gets called in the office and says that there was a complaint from a resident that you were harassing her, bothering her, and you know, this is unacceptable. So here's your letter of resignation, or you can get fired. Choose your poison. Pick your poison. So the guy fills out his letter of resignation. So how many people have been fired?
Wait.
How many people
I have
been
no
pulled?
idea what you're talking about.
Okay, well, you're going to find out, I guess. But the thing is, how much authority do I have in that matter? Where a person was pulled into the office and said, you know, basically offered to fill out his resignation form or get fired. What's a person going to do?
I have no idea what you're talking about.
I just said, you're going to find out, I guess, pretty soon. Okay, so,
I don't know
does he fall into the bucket of people who've been fired in the last year? No. But does he fall into the bucket of people who've been basically mistreated and treated unjustly and kind of pressured into resigning?
Departments are not allowed to ask people to resign. So I don't know what you're talking about.
Okay, well, that just disturbs me all the more. I'm serious. It just disturbs me all the more because here it is under your jurisdiction and your authority that this sort of stuff is going on. And
It is not going on.
okay.
So this is an employee, just so that we could
Yeah, give
backtrack.
me-
I'm
give
just
me-
using this example.
I'm
I'm
not-
falling my
I'm
lap.
not
Give me the
asking
name.
you to name a name.
Well, why
okay,
didn't you
but-
call me?
But I've got to assume that the employee, what you're saying is the employee tendered their resignation?
Correct.
So if we go back and we look over last month, or is this within the last couple
Well,
of
yeah,
months?
I assume he has a name if he spoke to somebody.
Yeah, it's within the last month or so. You don't even know anything about what I'm talking about. Nothing. Nothing even remotely rings a bell. So, like I said, that just disturbs me. How many, and I'm just using that case because I haven't even had a chance to get back to the guy because I just lost.
Well,
a friend.
usually, if something like that would happen, the employee would call me and say, what's going on?
Right, and the response I
And
got,
if they
don't
call-
even, don't even waste your time talking to Barbara D. Simone's like talking about. I said, don't waste my time. I said, that's the gatekeeper, unfortunately. That's the person I go through to the county. I said, but you know what, we don't even have a union contract, so it's really, I have very limited authority over what I possibly do.
You've called me on other occasions,
I
so why
haven't gotten
didn't
the chance, Barbara, if you listen to what I said, this happened a couple of days ago. Okay,
Well,
I've had
a little while ago you
contract
said about
negotiations,
a month,
ratification votes all this week.
you said within a month or so.
I just heard about it a couple of days ago. The resignation, I don't know why the person waited a few weeks to get a hold of me. But the point I'm trying to make is that I don't know how many cases that I don't know about, and apparently you don't even know about, where someone doesn't feel that they even have a fair shake going to the personnel board because basically you work for the same people that's moving to fire somebody. You do not have a reputation as being someone who's in the middle. You don't. You have,
Who's in the middle?
Yeah. In other words, you have the administration here, management there, and you have the employees here. And your typical human resource or personnel director is someone who's supposed to be an advocate for a working person. Okay?
Right.
You don't have that
Right.
reputation. I'm sorry to
Well,
say.
you talk to the disgruntled people. So of course you're
Okay,
gonna
well,
be.
yeah, you're right. I don't get any calls, people giving glowing reviews of, and I'm not trying to pick on you, but it's just the way the world works, okay? And the way it is here in Pasco County, people do not have the faith in the personnel department to get a fair shake. They don't. And so we're going, I'm just going to reel it back in.
We have
To answer your question,
2,000 employees, you hear a couple of disgruntled ones, and you make a sweeping accusation.
I've been here for a few years now.
Well, John, that's a good point. You have been here for a few years, and I think what surprises me about the story you just told us is that
That Barbara doesn't know anything about it, that surprises me.
no, I'm surprised that you didn't know anything about it before you got the phone call, because even though we don't have a contract, the union certainly represents it. We recognize that they represent the interest of the employees.
For the purposes of bargaining, yeah.
Well,
For
it goes
purposes of bargaining,
beyond that.
so
You've inserted yourself in issues other than bargaining.
And I've got the same
don't
result
take
every
issue
time.
with that.
And I got the same result every single time.
But
no cooperation.
you know that employee could have walked into that office at that meeting and said, I'd like to have my union rep with me. And made the call to you.
What is the union rep going to do? What am I supposed to do when we don't even have a contract? There have been a couple of cases.
You represent their interests under the status quo.
Right. A couple of employees have come to me over the last years, okay, and basically explained the situations to me. At least on 2 occasions, I've come to bring it to Barbara's attention to see what we can do to help the personnel. And it's always the same result. Well, the county's made the decision. And so there is nothing for me to do. There is no recourse. I become a witness, a bystander, and that's just not acceptable. When I say, what are we going to do to help this employee, and the county or Barbara says that, well, there's nothing to do. The person violated a rule. I said, well, you haven't thought about this? I thought, well, I'll look into it. A couple days later, no phone calls. So what'd you find out? Well, yeah, it turns out the person was guilty. Okay, well, I have reason to believe that they're not, and I have some evidence. Okay, well, that's not necessary. But it's just a joke. I have to have the ability to file a grievance to get someone's fair shake with a disciplinary matter, and not having a just cause provision in the contract is not going to allow you to do that.
I couldn't disagree more.
I'm sure you disagree with everything we say, so what's the difference? I'll tell you what, let's just call it a day, because
You have the right now
unless you have
to represent the interest of the employees under
if you have
the
any
status
desire
quo.
to have movement with a just cause provision in the contract, then let's talk. If you don't, then there's nothing.
We told you our position.
Wasted everybody's time.
You have the employee's name, so I can look at your
Like it's
accusation.
gonna make a difference?
Who's
The guy
it?
resigned, Barbara, he resigned.
Well, if
So you're gonna undo his resignation?
if he was forced to resign, then I need to,
No, he wasn't forced to resign.
I thought that's what you said.
He was sarcastic, facetious. You
Well,
don't
you
have to
know-
resign, but if you sign this, you
That's
won't be
being
fired.
forced to resign, and the manager has no right to do that. And if you don't give me the
I
name,
will.
you are
I will.
an accessory.
I will, Barbara,
You
I
know,
will.
don't make accusations to me.
Stop
and then-
pointing your finger at me.
I can point my
Well, I'll
finger
point my
all
finger
day
right back.
long. You know,
Because you're out of
just
touch with your
blowing-
own employees, Barbara, I'm sorry.
I have 2,000 employees,
Right. Apparently you can't handle the job. You
yeah,
made that
well,
one
you
of
do
it.
a hell of a job negotiating for your side, let me
Yeah, right.
tell you. Great job.
Yeah. One freaking provision that every contract has, you guys can't agree to.
Well, when the Teamsters were here representing the firefighters, they went to the personnel board. They had no
I don't have a problem
problem.
going to the personnel board. I told you that, I don't know how many times, a dozen times. I have no problem going to the personnel board. It's when we disagree with the results of the personnel board, we want to go to arbitration. It's not
Yeah.
freaking rocket science. It's not that difficult to understand.
Yeah, let's try a case twice. Why don't we try it 3 times?
You don't have the skills to try it once.
I need to wake up.
I need to tell them that